It's that time again. Look who I have with me. We can't get enough of you guys. That's what it is. It is time for another eviction hour. This is Christian Walsh, real estate agent with Wire Associates, and I've got my buddies Kenny, Raphael, and Zach here. People can't get enough of you guys, and I appreciate you guys coming. I know you're super busy. In fact, they literally had to kick somebody out of the office, I think, right, to come live. Did you kick them out, Zach, or what? Or are they sitting there?
They're not coming back. They're gone.
Oh no. I'm sorry to hear that. All right, so let's do a little bit of housekeeping, and then we're going to start to dive into questions. So it's time for another eviction hour. I appreciate you guys being on here. You guys literally, people end up tuning into these things. They love it, and they ask you to keep coming back on. So I appreciate you guys coming back on to do this. So we got Michelle in the background. She is helping with this live stream. So post your comments and questions. We got a bunch that we're going to run through, but keep your comments and questions coming. And then Michelle is going to keep it clean. So if there's anything dirty in there, Michelle will take it out of there. That's the fun job. All right. So last time you guys were on, we talked about you guys, and we talked about why you got into real estate, why you got into being attorneys. How's business been since I last saw you guys? Have you been busy?
Yeah, super busy. A lot of the cases that we get tend to be a lot more of the technical ones where we get no faults, just cause reasons. But it's because those are the newer ones. So we keep up with the laws on that, and we're able to, provide basically what we see as affirmative defenses or things to watch out for those cases. But we've been pretty busy with those cases mainly.
And you guys, so let's talk a little bit about logistics. So you guys, because I know I send a bunch of people your way. So if people have questions, they can give you a call. And you mentioned last time, Kenny, that there's a no obligation, essentially a free consultation that you'll do. And you've got your contact info. That'll be coming through. Michelle's going to make sure that's streaming. And then, so you guys spend part of your day doing that. You guys are in court. How often do you guys go to court and defend your clients? Just curious.
Almost every day, right, Kenny? I mean, we have at least 2, 3. Today we had 2 appearances. Today we have 3 tomorrow on 3 different matters. So, almost, I would say probably 7 appearances a week.
That's amazing, you guys. And what's interesting about that too is you also learn things during those appearances, right? About how the laws are being interpreted. Like I remember you said last time, security deposits and not paying a little bit of interest on those security deposits was allowing tenants to stay longer. Refresh our memories on that one, Kenny.
Yeah, so essentially, this is a pretty old law. I believe that was passed back in 2004. But essentially, judges have been tampering down on it a little bit harder, where if you aren't paying interest on the security deposit that you hold for tenants, that's going to be seen as an affirmative defense, and you're going to have to start your case over. So we've been seeing judges be a lot harder on that now.
Yeah, and that's because you guys are in court so frequently and doing those appearances, you guys see that stuff. And that, I think, is relevant too. The laws continue to change and will continue to change. And going into for those appearances, you're going to learn more about the law, and you're going to continue to stay on top of things. So despite looking so young, you guys do get it done and know what you're doing, and you're constantly learning. Just because somebody looks like they've been in the business for a long time does not mean they know what they're doing. Trust me. And just because they're an attorney, and this is both for landlords and renters, just because they're an attorney does not mean they understand landlord-tenant law. I get those phone calls, and I'm sure you guys do too, where somebody uses an form incorrectly or something like that. But my attorney did it. Well, that's because your attorney only does family law and they don't understand eviction law. Zach, what do you feel? How do you feel about that?
Oh, yeah, it's very true. And I have to say, Raphael Azizian just went up and did a jury trial. And we got a judgment in our favor just last week. So, even the attorneys who all they do is UD, sometimes they don't win. You got to pick a good lawyer.
All right, so let's get into some questions. So I made a list of questions, and some of these questions come from the folks that give me a call and they ask me questions. I give them the best answer I can, and I say, hey, talk to Kenny and the team. So let's start with this is something we talked about last time, which was the AB 1482, the Tenant Protection Act, and giving the exemption language. Some people who didn't give it at the proper time, and I should probably put that up. Let me put the infographic up because this is helpful. So you kind of have to squint, but this has some of the deadlines in there for giving the Tenant Protection Act disclosure, saying whether a property is exempt or not. So landlords who have missed it are able to give the 30-day notice of change in terms of tenancy, and they're able to give a renter the exemption notice, even if they didn't include it with the lease, which is now what they're required to do. So that's correct, right, guys? You have a number for that form, Kenny. What was the number for the change in terms of tenancy?
Yeah, so it's an 827 notice. It's basically just give a 30-day notice, basically amending in the exemption notice into your lease. And you could do that for any of these cases.
So my question is related to that because I actually talked to a tenant today who their landlord didn't give them the proper exemption notice with the lease, delivered at the exact same time a change in terms of tenancy, so that form, with the AB 1482 disclosure. So basically saying the property was exempt. So they gave those two items. Then at the same time gave a notice to terminate tenancy at the same exact time. And it was a 30-day notice to terminate tenancy when it needed to be a 60. So my question for you guys, are they supposed to wait longer to give they're basically supposed to wait 30 days after giving the change in terms of tenancy, correct?
Yeah, so you could think of it as kind of two separate documents. The change in terms of tenancy notice is a separate document that says after 30 days, this exemption notice is going to be part of your lease. After that point, then you can sit there and say, well, now I'm exempt from the just cause protections requirements. So here's a 60-day. It was nice having you, but I'd like you to leave for whatever reason.
Yeah, so and so when something like that happens where and by the way, this was served by an attorney, or the paperwork was filled out by an attorney, the tenant said, who obviously the attorney does not practice real estate law. So that notice being the way it was all delivered at the same time, that's an invalid notice, correct?
Yeah, if you bring that up at court and you really try to stand on that point, the likelihood of you prevailing as a tenant on that issue, pretty high in my opinion.
Yeah, so that would be to flesh that out. So basically, a tenant doesn't move out in their 30 days, even though it's supposed to be 60. Landlord moves forward with the unlawful detainer. Tenant answers the unlawful detainer so they don't lose immediately. And on their answer, they would list that they were given the change in terms of tenancy and didn't get the full 30 days, and a 30-day notice was supposed to be 60. So that's to flesh that out. So you get in front of the judge and lose. Now the landlord, and this dovetails into another question we got, the landlord could correct that by essentially giving a new notice to terminate tenancy, correct?
Yeah, so anytime a landlord loses, that doesn't really change the facts as to what's going on. I imagine at that point, the landlord-tenant relationship is kind of soured, and the landlord will try to do what they can to fix it. And the weird part about UD is that the courts will tell you what you did wrong. So essentially, you just got to fix what you did beforehand. You just lost the time and the money you spent in doing it wrong previously.
Got it. And did you want to add to that, Raphael?
No, I think Kenny covered it pretty well. You always want to wait until the 30-day notice expires before you follow up with a subsequent notice that you want to serve.
All right, so let me keep going with the questions. And if you guys have any questions, our chat function may not be working. So if somebody could write a question in there just to make sure it's working, we want to hear what you guys have to ask. Okay, so here's another one for you guys. So let's say so a lease ends. So a fixed term lease ends. So basically, let's say it's a 1-year lease that a renter has, and Does the landlord need to do anything to get the renter out if they just want the tenancy to end? Do they need to do anything? Do they need to give a notice to terminate tenancy? Can the lease end? I know this is a multi-part question. Can the lease end? Like places like LA City with their JCO, the Just Cause Ordinance, when a lease ends, can the landlord have the renter move out without having it go month to month?
Yeah, so it's going to depend on whether you're subject to any kind of eviction control or not. So the first thing you want to ask is, am I in a locality that has some kind of local ordinance? So that's going to be City of Los Angeles, Santa Monica, West Hollywood, Santa Ana, Pomona, Pasadena, long list of places. But let's say you were in Riverside, San Bernardino. You have a fixed term tenancy. That tenancy comes to an end, as all things do. You don't have to do anything in order to terminate the tenancy, assuming that you're not subject to statewide rent control. So that's this AB 1482. If you're exempt from statewide rent control, then on the date that the lease is set to end, they're supposed to be out. If they're not out, then the very next day, you can file an eviction case under Code of Civil Procedure 1161-1 for the termination of a fixed term tenancy, and you're in the process, you do the eviction, okay. If you're in one of those other local jurisdictions, you don't, or excuse me, if you're in one of those jurisdictions that has a local ordinance, or if you're subject to statewide rent control, you can't terminate the tenancy just because the lease expired. So you can either prep a new fixed term lease, if that's something you'd like to do, and give it to the tenant to sign, for a similar duration and with similar terms, or you can let it go month to month. But those are basically your options.
Okay, excellent explanation, Zach. And in that vein, let's say you're going to sign a new lease with that renter. So their 1 year lease is coming up, and you're going to sign a new 1 year lease with that renter, and you want to do a rent increase. Under state law, any rent increase of 10% or less is a 30-day notice. More than 10% within a year is a 90-day notice. A lot of landlords don't know that. They think it's still 60. So if you're going to have them sign a new lease and you're going to give a rent increase, let's just say it's a 15% rent increase. It's a property that's exempt from the Tenant Protection Act. It's a single family home. So you're technically supposed to give 90 days for that because it's such a big increase, but it's a new lease. Do you recommend giving them the lease to review 90 days ahead of time? Any thoughts on how to navigate that to make sure that that increase is legal?
Yeah, so that's a good point. It's not a bad idea to give them the lease to review, but I think that the issue here is that for 827 notices, if you want to amend a lease, you can only ever amend unilaterally a month-to-month lease. So if somebody's on a fixed-term lease and the landlord doesn't like the terms of the lease, landlord can pound sand, scream into a pillow, nothing you can do.
Yeah.
If you have somebody who's on a month-to-month, you can amend the terms of their lease by giving them the 827 notice that we had discussed earlier. If you're going from a fixed term to a fixed term and you want to do a rent increase, as long as your jurisdiction doesn't prohibit the amount of the rent increase you're giving, I'm okay with you just putting it into the fixed term lease and you say, hey, here's the new lease, here's what the rent increase is going to be, and if they sign on to that lease, I'm fine with it.
Christian, I think I understood the question a little differently than Zach did.
Sure.
Were you asking if before the fixed term lease ended 3 months prior, you served a 90-day rent increase, and then 3 months later, presumably the lease would expire, and then you would have the new rental amount? Is that
So,
what?
well, actually, great question, Raphael. And it brings up another point, and that is that when asking these questions, we have to know how to ask them. We have to run through the scenarios. So what I'm saying in this case is you're not going to let them go month to month. You're going to they're going to have a new lease that starts at the end of the previous lease. And that new lease is going to have a big increase that is 15%, for example. So you're, like I was saying, you technically have to give 90-day notice for that increase, but it's a new lease. So that's what I was trying to get at. I'd like your opinion on it too, Raphael.
Yeah, I think it's always prudent to definitely give the 90-day notice if you have the same tenants that are occupying the same property and they haven't vacated. Even though you're signing a new lease, it still seems to me like a rent increase. So if you're going to be increasing the rents by more than 10%, you want to give them the full 90-day notice, and also it must be in writing.
Yeah.
That's
Yeah.
something a lot of people, believe it or not, very frequently don't get correct. They do it over the phone, and it's a whole lot of trouble.
Text message. Yeah, no, that's actually a one that I did get a lot of phone calls about. They're like, my landlord sent me a text that I need to be out and by the end of the month. Is that valid? I'm like, they're doing everything wrong if they're sending you a text and telling you, oh, you have to be out by the end of the month. So, all right, so we got a fun question from Kate C. Your month to month in a rent control building, last increase was 2019. Technically, they weren't supposed to increase your rent. Well, yeah, they could actually. 2019, that was the last time. You just realized you haven't gotten an increase. They forgot you. What do? You stay hidden, Kate. Don't tell them. So that they would have been able to do a 4% increase most recently, but maybe it's coming. But if they don't use it, they lose it. Same thing with the Tenant Protection Act. If you don't use your increase, you lose it. This is a good question here that we have from WC. Is paying rent for 1 year upfront considered a de facto lease? No lease agreement. If so, does landlord need to give proper legal exemption language at end of year? I'm exempt from AB 1482. So what are your thoughts on that, guys? No lease, but taking a full year. Is that considered a fixed term, or is that a periodic 1 year term?
So it sounds like this is like an oral agreement kind of thing. So a lot of individuals kind of have this idea that if it's not written down, it's not real. That's not the case. Oral contracts are enforceable just the same as written contracts. They're just harder to prove. And there are certain contracts that have to be in writing. But generally speaking, if you have an oral contract, it's going to be enforceable. So if you paid up front for a year and you can prove that in court, you're going to have a lease. They can't really kick you out for having a lease for that 1 year period.
Okay. And then as far as the AB 1482 exemption goes, I mean, that should have been given. I mean, they should have had a lease, period, but that should have been given up front. So if they're going to keep you around WC1A, you really should get something in writing, and it should include all the proper disclosures. Correct, Zach?
Yeah, so we've had clients who have tenants who have they have an oral agreement with the tenant, and we've had to like amend in the required disclosure notice so that the only part of the lease that's in writing is this disclosure notice, because it has to be in writing. Additionally, you should know that if the lease doesn't provide otherwise, rent comes due at the end of the term rather than at the beginning. Most written leases will require you to pay rent on the first. As it turns out, if you have an oral lease, it's very difficult to prove that rent was due on the first, or can be very difficult to prove that rent was due on the first. And at common law, or rather at state law, rent is due at the end of the period rather than the beginning. So there are all sorts of reasons why you don't want to do oral leases. Yeah, maybe think about getting with the times. Writing is easy. More people are doing it than ever. It's not all hieroglyphics in cuneiform form like it used to be. We got, so, and you wrote this comment, so come on, let's get it.
Yeah, no, that's true. And then a big question people have, another common question is like, where do I get these forms? Where do I get a lease? Can I just Google it up? And I've released plenty of content on that. Don't Google stuff. Yeah, have you guys run into a case at all where your client or the client on the other side, you can tell they just Googled up some form or just made up their own version, and then you were able to win a case because of that? Kenny's smiling. What happened, Kenny? Tell me what happened.
It wasn't so much of a winning case. It was more the landlord walked into a nightmare scenario. He Googled some lease agreement. He was renting out a property in LA, and he got some kind of lease agreement from San Diego, and it required arbitration for all of their issues. And
In San Diego?
yes, from a mediator in San Diego, and he tried to file a lawsuit over it. It got dismissed because he had to arbitrate it. A couple of months later, he comes back to us and tells us, "Hey, the arbitration is going to cost about $25,000." And I'm like, "Okay, well, you shouldn't have Googled that lease. I don't know where that lease came from. That's really bad."
Yeah, so that's a great story, a great example. And I've seen a lot of invalid notices of termination of tenancy that didn't include the required language because people wanted to get fancy and just piece something together or just find something online. And I mean, it may work, landlord. You may find out that the renter moves out and everything's fine, but if they challenge it or you move to unlawful detainer, you'll lose if it doesn't have the right language on there. So to get forms, you can get them from a realtor you trust, a property manager you trust, or join an apartment association or landlord association. The AOA is great. We just did that trade show together. And then the AAGLA, we're doing that trade show coming up as well. We're going to be there next week. So those are great organizations to join and get the forms. So another good question here from WC1A. What's considered landlord retaliation? Do most retaliation cases win for tenant or landlord? Go ahead, dive in, guys.
Yeah, good point. So I've done quite a few jury trials. I will say that retaliation comes up quite frequently. And you have to understand that not every action that a landlord takes is considered retaliation. So what I'm really looking for that would kind of raise a big red flag for me is if a tenant complains about some sort of a habitability defect in the property, and instead of the landlord fixing it, serves them with an eviction notice, right? Mm-hmm. So that to me is like the most prototypical retaliation case. Also, a lot of times the way the retaliation defense works, at least in trial, is that even if the landlord has found to be retaliating, then they can still recover possession if it is proven that the eviction was for a lawful purpose. So as far as a legal defense is concerned, it's not the strongest that's available to tenants. At least that's been my perspective.
So you're saying in particular, for example, no fault, like they stop paying rent or set up a meth lab, and then the tenant tries to claim it was retaliation that they were evicted. That's not going to fly. You had to pay your rent and you couldn't set up a meth lab. Those are bigger fish than retaliation. So in that vein, I got two questions that come out of that, Raphael. I appreciate you bringing that up. Mm-hmm. So I do have a person I spoke with. They have an LA City property under the JCO. They received a notice from code enforcement to correct a few items, but they've also decided it's time to sell. So they basically want to terminate the tenancy under the JCO. They're going to follow the law. They're going to hire you guys to help, and they're going to hire me as the agent. We're the power team together, but they don't want it to seem retaliatory because it isn't. Quite frankly, they've been wanting to sell for a while. So any thoughts or advice on that, how to navigate that with the code, having something from code enforcement?
Yeah, sorry, question. I was trying to find the question and then I missed the first part.
No problem. I'll repeat it. So the question is, how do you prevent it from being looking like it's retaliatory when you're terminating a tenancy at the same time you've received a notice from code enforcement? So they don't want to kick the tenant out because of this notice from code enforcement. They just have decided it's time to sell and coincidentally have a notice from code enforcement.
Right. So as long as you follow the law fully and your eviction serves a lawful purpose and your story makes sense, I think with a good competent attorney, you have no problem overcoming the retaliation defense.
Okay.
Yeah.
So it really is a factual issue. So the judge or the jury will make that determination.
Got
whether
it.
or not you're retaliating.
Kenny?
Yes. Just to add on to it. You can really use just common sense when it comes to these kind of claims. The predominant reason for why the landlord filed the eviction has to be retaliatory for it to be a successful defense. So there's going to be a lot of facts that go into it saying, hey, Mr. Landlord or Miss Landlord, you got a notice from the city saying the building is, in a bad condition. And then instead of fixing it, the landlord serves a 60-day get out notice. It's like, that's a really big inference that this is retaliatory.
Yeah.
But if you have another reason to saying, well, I'm serving you this because I was thinking about it for the last year, I want to move in or I want to sell the property, I have another reason as to why I'm serving you this notice, that's going to be up to a jury or a judge to determine if your predominant reason was a valid reason or if it was retaliatory.
Got it.
Just to add, you really want to go quick on trying to resolve the issue that's raised in the order to comply. There is a presumption that attaches if you don't address that issue within, I believe, 3 months or within a reasonable time, 35 days or within a reasonable time. There's a presumption attaches that any notice that you give within 180 days of the receipt of the order from the city is presumptively retaliatory. So be aware of statutory presumptions. West Hollywood also has presumptions regarding when a landlord gives a notice in within a certain amount of time from a tenant complaint. So number one is move promptly to resolve the issue that came up with the order to comply. Number two, really put everything in writing and run it by a lawyer. Okay, please. I cannot tell you how many people, say dumb things when they get mad, tenants say dumb things to landlords and landlords say dumb things to tenants that then become really fertile ground for a retaliation defense. Okay. So try and keep it in writing, keep it above the belt, and make sure you're moving quickly to resolve those orders to comply.
That's great advice, Zach. And that's definitely talk to an attorney, because I've had cases where people say, hey, I want to send this note to my renter. And I'm like, no, talk to an attorney first, have them word it correctly. And they were trying to be helpful. They weren't trying to be like rude answering an email back. Like, they're trying to be helpful. I'm like, stop being helpful, stop trying to fix things, get an attorney involved. And that's where you guys are good to have to turn to. So Raphael, we were talking before we came on, speaking of habitability, you had some good advice for landlords.
Yes.
Related to habitability and when renters are moving in. So tell us about that.
Right. So recently I had a client come to me. They were being sued for habitability. And in my head, I was thinking, well, what could you have done better earlier so it could have helped me win your case for you, right? So I thought about it. And in my opinion, the best thing you can do is when you're renting a property, the tenant's coming in for when you show the property and you have already signed the lease and the tenant's about to move in, you do a walkthrough and you take a photograph of how the premises looked at the time the tenant moves in. That way, everyone knows that this is what the property looked like at the beginning of the tenancy. And if the tenant damages a property on their own, you'll have a really killer defense for a future habitability defense, right? If you didn't contribute it as a landlord yourself. And also, if you want to be extra prudent, you could also do annual inspections for some of the older tenants. Just go there every once in a while, once a year, to do an annual inspection to see the condition that your property is in. That will help substantially. And also, you could be put on notice for any defects that the tenant might not have known about, and you can just take care of it. So it's just good. It's just really good business practice.
No, that's great. So I fully agree with you. Taking pictures just before giving possession, you can just use your phone. You can shoot video easily with your phone. I have a 360 camera that I use. Pick up a 360 camera. What's great about those is you just plop it in the middle of the room and it takes a picture of everything. Having those pictures will be great so that you can prove, hey, this is what the carpet looks like. I mean, basic stuff like carpet outlook, what color were the walls? Like, I hear from people on that stuff all the time. And then more complicated stuff like, was there a hole in the ceiling or not? Like, we'll look at the picture. And then as far as your annual inspection, that's great advice. You can give a notice to enter to test out smoke detectors, carbon monoxide detectors. That is a valid reason. And something I encourage you to do is actually go test those, because it's for the safety of the renter and mitigation of risk for the landlord. And at that same time, see if they have any extra people living there. look under sinks, see if there's any issues with water intrusion, etc. I think that's great advice. All right, so let's get to some questions. We got Maria has a good question about how much notice is needed now for month to month if you're selling. So I'm going to jump in and I'm going to let these guys jump in. So there's a lot of misconception out there. You have to give 120-day notice before selling, and Google has it wrong. I released a video on that, and people still ask me that question. The 120-day notice is related to being able to give verbal notice to enter the property, has nothing to do with having to let the tenant know 120 days before you're going to sell. Now, the other important thing is in here, and I'll let these guys take over, selling a property is not technically a valid no-fault reason to terminate a tenancy. So if the property is subject to a just cause ordinance like the Tenant Protection Act or a local ordinance, selling it, you can't just write, hey, I'm selling the property, and that's valid. So if it's exempt from Tenant Protection Act or exempt from just cause, you don't give any reason, but saying it's for sale is not a reason. Okay, jump in, attorneys. You guys are the real guys to talk about this. Zach, anything? Or Kenny, go ahead.
Yeah, so you pretty much hit everything on the nail on that one. The only thing that I would really add is that if you are trying to sell the property with a tenant inside, nothing is stopping you from selling the property with a tenant inside. It's just it would lower the value of the property. You're going to have to find a just cause reason under either the local ARSO that you're a part of or the statewide variation that you're a part of. And if you're exempt from any of them, then it doesn't matter if you're selling. It doesn't matter if you just want it empty. You could just serve a flat 60-day. So it's just going to matter on whether or not you're subject to any of the just cause ordinances or not. But selling is not a no-fault just cause. A lot of legislatures kind of said, I don't care if you're selling. That's not a reason for you to evict your tenant.
Yeah. That's why you reach out to me and we talk about it first, because I'm the real estate broker, and I tell you, hey, these are a few of our different paths. And then I connect you to Kenny and Zach and Raphael to figure out legally what you can do, because sometimes there's surprises. A recent one that was a surprise for me was in Compton. It was a single family home, essentially. And in Compton, if it's a single family home, it's exempt from AB 1482. There isn't any local ordinance that supersedes that. But we mapped it, and this one, even though it was Compton, it is LA unincorporated. So Kenny got to go ahead and share the lovely update for me. Kenny, what reasons can we terminate a tenancy in LA unincorporated? You've got a short list, if you remember.
Yeah, it's really short. It's like 3 only. It's basically withdrawal the rental unit from the market or owner move-in. Those are the really big no-fault ones.
Yeah, and that's full Ellis Act withdrawal. That's not, hey, 60-day notice. This is goes on title. You've got to follow the letter of the law, and the future owner can't rent it out without having issues with Ellis Act. So anyway, talk to us first. But so let's keep going. So Maria, the answer is 60-day notice. If the tenant has been there more than a year, it's a 60-day notice, terminate tenancy. Less than a year, 30-day notice. Section 8 is a 90-day notice. Ellis Act is a 120-day notice or longer. So as you can see, talk to Kenny and the guys before you give any notice. All right, let's see. Free Builder, thanks for coming out today. Nicely done repairs and significant renovations done without permits be considered a habitability issue. That shouldn't be, right, guys? Run through some habitability issues or problems, things that a landlord, if they didn't take care of, would be in trouble for.
Yeah, there's actually a list of it. I can't think of the statute. Maybe Zach, do you remember? It's like 1946? No, 1940.
Yeah, start looking around 1942, and then go either one up or one down, and you'll find it. I think it's 1942, but don't.
Yeah, it's one of the statute lays out clearly what it is, but in summary, it's like floors, windows,
heater. Must have heater.
Yes,
no pests.
Exactly. Rodents, insects, it must be clear of those things. The flooring must be in good condition. The walls must be in good condition. The pipes must be in good condition. Mold, free of mold, asbestos.
I thought you were going to say the mold has to be in good condition, but no.
Must be free of
no
mold.
No mold.
Yeah, the big structural stuff, obviously, and then anything that can pertain to a health hazard, and obviously like windows and walls and things of that sort are habitability issues.
Perfect.
Appliances are not.
So
good to know. Oh,
I guess just to add on to that as well. Essentially, it sounds like there's questions about should the landlord get legal permits to construct any kind of additions or make any changes to the building. Bottom line is you should always follow the law. You should pull the proper permits to make alterations to the premises if you need them. Now, does a tenant have a cause of action for habitability against a landlord if it's not done without permitting? Not necessarily. If it's basically going to fall short of code compliance for habitability issues, as the ones that we just listed, then yes. But if it's only lacking the permitting, then no. But the city can come down to the landlord and say, hey, you didn't do permits for this. Like, we're gonna, give you an order to comply. You have to get permits for this.
yeah. And then I get so excited talking about this stuff. Let's just talk real fast, Kenny. A property where you've decided to add a unit illegally, a bootleg unit in RSO, under the RSO in LA City or LA County. Tell them the lovely side effect for all the rent that you've collected for that, because I love that one.
Yeah, so it kind of goes down to the basic idea that if you have an illegal unit and you're renting out an illegal unit, guess what the fair market value of an illegal unit or illegal commodity is? It's $0. So basically, if you're renting out something that's illegal, you can't collect rent on it. And if you've collected rent on it, there are some local rent control ordinances that say you have to pay all of that back. Every single dollar that you receive from the tenant, you have to pay it back. So that's a huge problem.
Thank you for that, because there's actually, I won't give any details out, but I talked to a landlord who's interested in selling, and she inherited a bootleg unit with some tenants in it, and she's interested in selling the property. But I'm warning her, hey, you need to get that taken care of before you attempt to sell this property, because it could become an issue during the sale that suddenly this renter finds this out and wants all their money back, or the new owner takes over and then suddenly that happens, and maybe they decide to go ahead and say there was fraud and come after you. So anyway, that's another nice surprise there. So no, do not rent out bootleg units. Okay, we'll go through a few quickly. Relocation payments necessary for exempt property? No. Let's see what else. This is good to see here. Free Builder 007 inspection. You had tenants deny entry to do condition inspection. So if you're giving proper written notice and they deny entry, what can a landlord do?
You could serve a 3-day perform or quit notice.
Yeah.
I don't want to evict any purpose of annual inspection.
We lost Raphael. We're losing you, bud. You might have to reboot. Oh, that's better. Good. Go.
So I was saying that. So you could. there's for denial of access, but
you're gonna have to reboot. Sorry, Raphael. Reboot and come back in. But yeah. So Free Builder of smoke detectors, carbon monoxide detectors, those are valid. That's right on the notice. The California Association of Realtors notice of entry has those boxes you can check. Let's bring them back in. An inspection for overall condition is not actually one of the valid reasons to enter a property. It's those specific things. It's also to show prospective buyers. You can show contractors and vendors. Those are valid reasons to enter as well. So anything to add there, Zach?
No, you hit the nail on the head. So yeah, generally speaking, if you just want to do an inspection and the tenant wants to deny you entry, there's nothing really that you can do. Most of the time, they'll let you in to inspect because you're trying to find things and fix them, behaving like a good landlord. You're not just, I don't know what, out in Turks and Caicos sipping a margarita. So they're usually pretty happy that you want to actually, fix stuff. But yeah, if you're just doing a general inspection and they deny you access, other than, I believe, for smoke detectors, not a lot you can do.
Yeah. And then Timothy brings up here, he's talking about the tenant can't deny entry. That's right. Question is the right to quiet enjoyment. So do you guys want to touch on quiet enjoyment at all for a renter? Any opinions on that? When is a landlord violating quiet enjoyment? Any thoughts?
Well, when you're constantly trying to, perhaps like if you're trying to do an inspection every single day, that would be
Yeah.
kind of weird. If you were hitting them with a 24-hour notice of entry, or actually not even giving 24-hour notice of entry, just showing up at the property like 5 times a week, saying, "Hey, I'm here. I want to do an inspection." That's kind of weird. I would say you're interfering with the quiet enjoyment of the tenant. Also, any kind of nuisance, a landlord can also. I guess it would more be coupled with harassment. There's a comprehensive list of actions that a landlord is not supposed to do, which could potentially subject you to the tenant anti-harassment ordinance.
Yeah.
So,
Good point. And there's and some local spots like Santa Ana has an anti-harassment ordinance. So you just need to know locally what, as a landlord and as a renter, what is considered harassment.
Failing to do repairs, that's one of them as well. So if you're constantly
Interesting.
being put on notice about repairs and you fail to do it,
Yeah.
that's you're interfering with their quiet use and enjoyment, and also could under LA City is considered harassment for you to not do that.
That's great insight. This is from Sherry. So Sherry, I'm assuming you're the renter. So Sherry moved in before discovering this unit has no permit with the city. So if it's LA City or in LA County, you can get all your rent back. But that's a whole other. Would you guys want to help with that? By the way, would that be good for you? Could you do that on a contingency basis? I'm spitballing. I know I shouldn't do that. Would you help with that if renter? Your call.
We'll talk to anybody who calls us.
Yeah. Well, I think it's worth. I think case by case basis. So if a tenant stays after discovering the heat vent is controlled by another unit's tenant, has she given up any rights? If she essentially finds out it's illegal and doesn't actually have heat, she's relying on another unit. She's not giving up rights by staying, is she?
No, so you're looking for statute of limitations issues. So you don't have forever to file a lawsuit. From the moment that you learn of the condition, that's going to start the clock ticking. I don't know off the top of my head how long you would have. Would it be the matter of say 3 years, 2 to 3 years? You're also kind of like getting to something called the delayed discovery rule, which stays or tolls the statute of limitations for a period of time where a person is ignorant of the cause of action. So if you moved into an apartment and then come to find out 10 years later that it's got, I don't know what, crocodiles, bees, mold, whatever you want. If you didn't know, you are not, the statute of limitations doesn't start running. But once you find out, you want to act really promptly, go call a lawyer and make sure that you haven't already blown the statute of limitations.
So a couple more questions. So this is from Christian P. If a landlord decides not to renew a lease due to selling the property, are they required to provide relocation? OC never provided AB 1482 language. So this actually, I'll let you guys answer, obviously. But Christian, what may be relevant, and I'll let these guys answer. So in this case, if he's not month to month, it's just the lease coming to an end. That's one thing. But if he is month to month, then it would be different. Now, if you're month to month, which it doesn't sound like you are, if you're month to month, you're in Orange County, property is exempt from AB 1482. If you didn't get the proper exemption language, then he needs to give you relocation assistance. But if he gives the change in terms of tenancy, it gives you the exemption language, waits 30 days, then gives you a valid 60-day notice, then you wouldn't be owed relocation assistance. But let me have you guys answer. If the lease is coming to an end and the landlord doesn't renew it, I mean, it doesn't matter, right? Even if he says he's selling, he doesn't need any reason to not renew a lease in Orange County, correct?
Yeah, so you would still have to get an exemption from the TPA somehow. So if you're exempt from the TPA, then you could just go ahead and say, I'm not renewing your lease. Your lease terminated 2 days ago. You need to be out. You're still there. So I'm not going to accept any rent moving forward.
Yeah.
So you either need to get out or I'm going to file a lawsuit. If you are subject to the TPA, then, like we said, discussed before, selling the property is not just cause under the TPA. So you'd have to find a separate reason to do an eviction. And if you were to do a no-fault reason, you would be owed 1 month of relocation if it was a no-fault.
Okay. One more question. Oh, actually, so this is a quick and easy one. He owns and rents a San Diego property, not LLC, not a REIT, built 25 years ago, not a duplex. Is this rent controlled? If it's in San Diego City, you'd have to double check the San Diego City ordinance. But if it's outside San Diego City, then no. It sounds like just a single family home, and it'll be exempt from at least the Tenant Protection Act. You guys agree?
Yeah, I guess, I mean, there's a lot of things that aren't duplexes, so I guess it depends. I mean, if it's a single family home, or if it's a giant, multifamily, if it's a triplex. So, but yeah, if it's single family and you qualify under one of those E8 exemption notices, you give the notice to the tenant. Could be, yeah, it's a fun, like, kind of like almost law school thing where, yeah, not duplex means single family, means triplex, means what? Yeah,
that is a very attorney answer. It's everything outside of the category of duplex.
Yeah,
that's yeah. All right, so good question here. Screening tenants, can you reject applicants based on the debt to income ratio legally? So as long as screening tenants, make sure you have the same rules for everybody. That's how you avoid fair housing violations. What I'm curious is where you're getting the debt to income ratio, because that's more advanced than what a credit report. Well, I guess you could do the math to do it, but you would agree. I mean, debt to income, as long as you've got the number for everybody and you're using it the same ratio, that's legal, right?
Yeah, I think so. And I think just be, I don't know how to put it. If anybody starts breathing reasonable accommodation, then start talking to lawyers. So sometimes you'll have it be that, whatever. There are cases from around the country where somebody would say, because I have HIV/AIDS, I'm unable to work, but my mom will be a co-signer, and I want you to make a reasonable accommodation to your screening requirements, something like that. Just be very cautious if anybody starts talking to you about a reasonable accommodation, but generally speaking, you're good to go.
Greg clarified it's a single family, 2-bed, 2-bath. So yeah, that was good though. You were right on that, Kenny. Or Zach, sorry. So let me see. Okay, so did we talk about the one of the questions from somebody who called me was about the Tenant Protection Act. So it's a corporate owner that subleases to an individual, or it's a corporate owner that leases to an individual. That individual is allowed to sublease. So is that individual exempt from the Tenant Protection Act as a subletting landlord? Thoughts on that?
No, so you need to kind of fit the definition of what the E8 exemption does. You're a corporation, so you don't fit under the E8 exemption. The simple act of subletting it doesn't necessarily mean that you qualify for an exemption out of the TPA. The exemptions in TPA are pretty straightforward, and they list out exactly what you need to do. And trying to figure out, well, I did this other thing that's not listed there. Well, it's an opt-out. It's not an opt-in. So unless you can find out how you can opt out of the TPA, you're part of the TPA.
Yeah. Now, some corporate, not corporate, nonprofits. There's when I've run through the list of exempt properties for the Tenant Protection Act, I don't share in my videos every single exemption, because there's a lot of smaller categories that nobody watching, like dormitories are exempt from the Tenant Protection Act, and there's not too many colleges watching my videos to see if they're exempt, so I don't go into that. And then certain nonprofits are exempt as well from the Tenant Protection Act. Section 8, if the entire project is a Section 8 project, not just taking a housing choice voucher. That's an important distinction that a lot of people early on didn't understand, that the project or the unit has to be a Section 8 designated unit. Just saying you took a housing choice voucher for your non-designated Section 8 unit, that would be exempt in that project.
Asylums are also usually exempt. So if you come to our law office, we're exempt as an asylum.
Insane asylum. Tim uses debt to income on every application, and let's see, Maria does as well. I guess Yeah, the way I'm looking at it is a way like lenders use it, where they actually add up all the actual debt. Um, Typically, when you do pull a report through TransUnion, you don't have all of that. But hey, that's fine. That's good. Whatever you can use legally. If a landlord cancels our lease due to selling the property, but they find out they rented it out again, could we pursue that? Now, the question on that, Christian, is if it's exempt or not. If it's exempt, I don't know. But if it's subject to the Tenant Protection Act, I think so. So
Yeah, so the time to actually make that argument would have been if there was an unlawful detainer or an eviction filed. There are cases where, if you're referring to like owner occupies, where the landlord is stating in a declaration stating that they'll move into the unit, there are causes of action where the tenant can sue the landlord or have right of first refusal if the landlord decides that they're going to move out, they're not going to stay in there for the required period of time after the eviction occurs. But if it's what you're referring to with just selling the property, you have to find out if it was exempt from the TPA or not. And the time to bring that up would have been during the unlawful detainer action.
yeah, so dovetailing into that, we've had some issues with our comments. We're not getting all of them. Just to let you guys know, we're doing our best to put the ones up we're getting where it's a technical issue. Anthony Vallone was asking, if a tenant is evicted, have a family member move in, how long does the family member have to stay in the unit? And then what happens if the family member has to move out before? So SB 567 changed that for the Tenant Protection Act. They're supposed to stay there. I believe it's a year for the statewide Tenant Protection Act. And then if they move out in statewide, if they move out before a year, the renter can actually move back into the unit at the same rent and then also be paid for moving expenses. So don't screw around with it. Of course, if there's a circumstance like somebody died, like you could probably fight that one. And then I know specifically that there are requirements under RSO. So Kenny, you might be able to, or Zach, if you want to jump in, but the RSO has specific requirements. Oh, Raphael, how long is it? 3 years?
Oh, it's 3 years. Yeah, it's 3 years for the city of LA, RSO, and also just cause.
Yeah, so like any law out there, look at the statewide level and then look at the local level to see what the requirements are. So let's see, what else did we want to talk about, guys? Oh, Raphael, you were bringing up, and this is an interesting one, is using security deposit for rent. So when you sign a California Association of Realtors lease, for example, it says that the security deposit cannot be used for rent. So whatever security deposit you're getting, that has to be used as a security deposit. Some landlords will say, "Oh yeah, go ahead. We'll use it. We'll use the security deposit for the last month's rent." What other examples? What is your opinion on this, Raphael?
Yeah, for some strange reason, I got two issues 2 times. This came up last week, and it's just such a headache. So clients called. They had used the security deposit to cover 1 month of the rents that the tenant was delinquent with, and I have an issue with it because it creates a whole sort of accounting problems about how much we're supposed to put on the notice about for which month the security deposit was applied to. So we can always overcome it, but it's just too much of a headache. Security deposit is just a security deposit. It's not rent. You want to save it for when the tenant leaves the property and use it for any damage that you suffer as a result of the tenancy. Don't apply for rent while they're still living there. It's just not good business practice.
Yeah, and it's about
even
to
if
change.
the tenant asks. Even if the tenant asks.
Just say no. Say, look, you still have to pay that last month's rent. Also, people don't realize too, when you're served a 60-day notice or 30-day or 90-day, a renter, you still owe rent when you're in possession of the unit, unless it's subject to some sort of relocation assistance and they're able to waive rent in lieu of relocation assistance, and the notice would have to specify that. But yeah, that's a common question, especially with single family homes that are exempt from Tenant Protection Act. You have to keep paying rent through the end, and you can't use your security deposit to cover that. So here's a question for security deposit. can the landlord use a security deposit for late fees that weren't paid? So Elsa, are you saying while you're still a tenant? Or are you saying on move out? And you guys can address both of those. So this would be basically probably what I'm guessing, Elsa, is you don't feel like you owe those late fees, but the landlord just went ahead and deducted them from your security deposit and you're still a renter. Thoughts on this, guys?
Yeah, so the landlord can use the security deposit to pay off any outstanding obligation owed by the tenant after the tenant vacates the property. If there's any kind of dispute as to whether or not it was properly applied to a debt that was actually owed, you're going to have to bring that up in small claims court, unfortunately, and have the court decide that. Late fees are enforceable. It's basically there's questions about whether or not they are going to be seen as liquidated damages or not. But most of the time, late fees, as long as they're reasonable, are going to be enforceable. And if there's an outstanding balance when the tenant vacates, the landlord can apply the security deposit to any outstanding debt.
And then just to further tack onto that, a landlord has 21 days after possession is given up to get the security deposit. If there is a balance, get that to the tenant, and they must give a breakdown on what the deductions were for. And so if they miss that 21-day deadline, they're not allowed to deduct anything at all. So that's important for renters and landlords to understand. Don't miss that deadline, because what'll happen next, the issues over security deposits would go to small claims court, and you'll lose if you got it back to the renter with all these deductions. After 21 days, you lose. So one more, and then we're going to wrap up here because we're coming up on our hour. So, and this is a good question because I've had people ask this. So when serving notices, is it the landlord's burden to prove they tried to serve it personally before posting and mailing? How often have tenants been able to use this to get cases dismissed? So let me flesh this out. So when you're delivering a notice, the first thing you're supposed to do is attempt to give it to the renter. You're supposed to knock on the door. Don't be afraid. Hand it to the renter. Next would be substituted service. Hand it to another person who's 18 or older on the property. The next would be to post it to the door and mail a copy. And then the least favorable would be to send it via registered or certified mail, depending on what it is. So if the landlord didn't knock and just posted, and there's proof, like there's a ring cam and there was no knock, could they lose for that?
Yeah. Oh yeah. I've actually heard about someone losing a case because someone said they didn't knock, they just posted it. And I've also seen someone lose when they said they posted it after knocking loudly and not mailing it.
Yeah.
Also, it's not just that you have to try to personally serve. You're also supposed to try to ascertain. Technically, you're supposed to ascertain their place of business. So you're supposed to try to find where they actually work. So if you actually know their place of business, where they actually work, the law says that you're supposed to try to serve them at their place of business before posting it. But a lot of times the landlord or the process server don't know where the tenant works. So you just move on to the step of trying to serve it personally. So they've got pay stubs.
They've got pay stubs if they screened them. But no, that's great insight. Yeah. So Maria, see, this is worth the price of admission. Maria says, I've always posted in certified mail. Yikes. Yeah, got to go knock on the door. Anything to add to that, Zach? Have you had any experiences with that?
Oh, yeah. So same thing if you're doing a commercial case, if you're a landlord renting to somebody who's doing it commercial, the inverse also applies. So try and find their residence. Additionally, if you're doing a commercial notice, it's not enough to go once, knock on the door, can't find anybody. You got to go twice. You got to use reasonable diligence when you're posting and mailing. I don't know why they make all these rules, but they do. You can check them out for yourself. Code of Civil Procedure 1162. They're there in black and white. And so, yeah, it's our job to know them. Unfortunately, we don't get to write them. But yeah, so if you're going to serve a commercial notice, post and mail, you got to go twice and try and find their residence if you can.
This is totally worth the price of admission. This little bonus at the end. All of us are learning something. Not you guys, because you already knew this, but I'm learning stuff, and I could see in the comments people are learning. So, all right, so we're going to wrap up. It's been an hour, which always flies by with you guys. Kenny, give us your spiel on why we should use you guys.
Yeah, so the biggest reason I think or the biggest edge that we provide, I think, is we are always looking to move the case forward for anybody that hires us. There's a lot of attorneys out there that will look to try to just delay the case, or they're not sure how to prosecute the case. We have we have a lot of experience with jury trials. A lot of the times tenants are asking for jury trials. We like Zach had mentioned before, we won a jury trial last week. We took that case actually in early February and got a judgment all the way through a jury trial last month. So it took us 2 months to go from the case initiation all the way through to the jury trial. So a lot of attorneys can't do that. A lot of attorneys, they'll flounder. I've seen attorneys take cases on where it'll take them 6, 7, 8 months to get to a jury trial. We actually subbed in to a couple of other cases from another attorney, and his cases were filed back in 2023, back in August, July, June of last year, and he just couldn't prosecute the cases out. The thing with us is that we're always upfront about what we do, and we always announce ready. I know that sounds kind of like an insane thing to say, but we announce ready. We're always ready to prosecute the case forward. And that's the reason why I think that we have the edge over other attorneys.
And you guys are actively out there practicing specifically landlord-tenant law every day. You're going to the courts like we talked about in the beginning. You're continuing to sharpen your sword, if you are allowed to have swords. I don't think attorneys can have swords, but you do that. And what I like about you guys is we can get you on the phone. And I send a lot of people your way. So if you have to wait to hear back from these guys, it's my fault because I send them so many people. But if you guys will be honest with somebody. If you basically tell somebody that you can't do anything, then that means nothing can be done. So just to let you know that they're honest guys and they know their stuff. So I appreciate you guys being here. We are going to all be together. Are all of you guys coming to the trade show next week on Zach? Are you coming or what?
I'll be there. We'll make it work.
Right.
We'll make it happen.
For a little bit. We need you guys there. So we're going to be at the AAGLA Income Property Expo next Wednesday. It's at the Pasadena Convention Center. And basically you walk in, tickets are free, parking's expensive, but it's worth it. Still come and see us. Tickets are free. Walk in the door, look to the right, and you'll see us. And come and ask us your questions. Come and high five. Take a selfie with Kenny. He loves selfies. You can tell by the smile on his face. He loves selfies. So please, we want to see you guys come by there. I know that All Nighter, who asked a lot of great questions, he's coming to see us, by the way. So we're looking forward to seeing you guys there. Reach out if you have any questions. Oh, yeah. Michelle in the background says we're in booth P1. Go through the door, look to the right. You'll see us. P1. If you guys have any questions, you can reach out to these guys directly. We've been streaming their info below. Also reach out to me as well. This is part of the power team that you get when you hire us for selling or buying property as well. You get me, you get these guys, I have contractors, etc. So we can help you from beginning to end. We can get the deal done. So just wanted to throw that in there. Thank you guys very much for coming out. Raphael, go take care of that little newborn who's growing up very quickly. Raphael had a stroller in the background. We moved that before the video started, but I think you should have left it personally. I'd love seeing that. All right. Well, thanks for coming out. This has been Christian Walsh, real estate agent with Wire Associates, and Kenny, Zach, and Raphael from California Property Law Group. And we'll keep doing